how to avoid the metaphorical fourth-headed monster nursing homes. Oh my. Hey, Elder Law Care Warriors, Patrick Kelleher at elderlawcare.com. Hey folks, today's subscribers' email question is the following. Hey Patrick, can Medicaid take the family home after I pass away? Folks, that's a really important question, and you need to get your head around the answer. And so pull up your chair, get your notebook out, and get your pen ready, because I am going to answer that question today at elderlawcare.com. Folks, can Medicaid take your home after you pass away? It depends. It depends whether you're a single individual, and depends whether you have a spouse that is still living in the community. It also depends on the state and jurisdiction that you may be in. So you want to make sure that you work with an experienced elder law attorney in your state, in your jurisdiction, because the Medicaid rules for what they refer to as Medicaid Estate Recovery Program can differ from state to state from my experience. Sometimes they can be a little more aggressive, and they have a little bit longer arm of the law to do that estate recovery or lien on the family property. Here in the Commonwealth, from my understanding, Bill and Mary, we'll say Bill and Mary, and Bill ends up incapacitated in a nursing home, receiving Mass Health Medicaid benefits, okay? Well, typically, if Bill and Mary, like most folks, are holding title to their home, we'll say they're holding title to their home as Bill and Mary, husband and wife, right? When Bill receives Medicaid benefits, Medicaid's going to be interested in the home. However, if Mary is a joint owner on the home as the surviving spouse living in the community, and if Bill in the nursing home, the less healthier spouse, passes away first, there's a thing in the law called right of survivorship to the other joint owner, wife Mary, in the community. And that would be a good thing to help that couple avoid losing their home to the nursing home, because the house would vest 100% in the surviving spouse, Mary, in the community, and avoid the first-headed monster, probate court. And that is when Medicaid gets notified typically, when an asset goes to the probate court, because that's like the Roman Colosseum. There's a notification requirement via certified mail to the Mass Health Medicaid Department here in the Commonwealth, and then they would plug in the decedent's social security number, date of birth, and name. We'll say Bill in the nursing home, and they would say, hey, Bill is still in the nursing home receiving Medicaid benefits, or if he had recently passed away receiving Medicaid benefits, they'll be looking to place a lien on the family home. However, if Bill dies first in the nursing home, right of survivorship to wife Mary, avoids probate court altogether, no lien on the family home. So that's a big win right there for the family. However, situations don't always turn out like that. Another scenario which potentially happens, Mary is the caregiver, like my late mom was for my late dad, who ended up in a nursing home. Being a caregiver is a very stressful job for the caregiver. And I've had cases like this as well, where the caregiver goes first. So if Bill goes into the nursing home receiving Medicaid benefits, and all eyes are on Bill, the nursing home spouse, and you're thinking, well, the house is held jointly with Bill and Mary, and Bill's the less healthier of the two, he's likely going to go up to the cloud first, and then a big surprise happens, catches the whole family off guard. Mary, the stressed out caregiver, goes first. When Mary goes first, right of survivorship to Bill. And that's not a good scenario, because Bill is completely incapacitated. Now, he gets the house, and you don't want him to get the house, right? Because he's in the nursing home receiving Medicaid benefits. And then if Bill passes a short time thereafter with no joint owner, the house is going to end up where again? In probate court. And that's where Medicaid would likely make an estate recovery on the family home, because Bill, the nursing home recipient receiving Medicaid Mass Health benefits, had an asset that went off to probate court that automatically notifies Mass Health Medicaid, and now they're permitted to enact or employ estate recovery. So a transfer of property is typically really important. And then you can go another layer beyond that, because now you have to forecast and predict and counsel what if Mary becomes incapacitated in the near future. So typically Mary should work with her experienced elder law attorney and maybe perhaps look to put her property, after it's transferred to her, into a Medicaid asset protection trust so she can get the 5-year clock running after, of course, her husband Bill receives and is approved for Medicaid benefits. Long and short of it, make sure you work with an experienced elder law attorney regarding the legal technical nuances of this type of planning and this type of protection. Folks, thanks for joining us here today. Hopefully you found this video helpful. Please click the subscriber button and click the notification bell because we will continue to keep you updated on other important elder law matters as we proceed. Thanks for joining us today at elderlawcare.com.